So thank you for joining us today. Bob Waldman, co-chair of Venable's nonprofit practice. Several members of our nonprofit group are here in the audience, and we welcome you all to the first of our monthly seminars for 2018. Today's topic, as you'll see, privacy and data security trends and issues for nonprofits in 2018. For those of you who are seeking it, this program is available for CAE credit, and we will be sending you information on, if you don't have it, on how you go about making sure you get that credit. Just a brief introduction to some programs that are going to be coming up that you might want to mark on your calendar. We hope you can all join us on it, and those of you who are on the webinar portion also. February 15th, nonprofit mergers, alliances, and joint ventures. And that should be a good program. And then March 15th, and obviously something we're all dealing with and updating our documents in accordance with, sexual harassment. What should nonprofits be doing to keep itself out of the headlines and out of hot water? So I think I've gotten more phone calls over the last couple of weeks about updating employee handbooks and policies on that topic. So that should be a great session, and we hope you can be available to join us for that. So coming back to today, obviously we all deal in a world where cybersecurity, data protection issues are critical. We deal with them every day. Every day we see something in the paper about a problem somewhere, and I know we're all struggling with it. Particularly acute with nonprofits, given mailing lists that you have, which can be fairly large, donor lists, et cetera. And in particular, it's relevant because and I didn't know what this was, so I'm not trying to dazzle you with my intellect here. The GDPR, which I didn't know what that was until earlier this morning, but the GDPR apparently comes into effect in May, which should have some far-reaching ramifications, and we'll be speaking on that today. We're very lucky today to have two terrific speakers here. First, to my immediate left, my partner, Kelly DeMarcus-Bastide, who's a member of our e-commerce, privacy, and cybersecurity practice here at Venable. And I've worked with Kelly. She is absolutely terrific on this. And we're thrilled to have joining us Joel Urbanowitz from Catholic Relief Services. Joel is the Director of Information Security and JCT Process Governance at Catholic Relief Services. So with that, I'm going to turn this over to the two of them to sort of walk you through this. Now, for those of you who are here live in the audience, if you have questions, just raise your hand. You can do it during the talk. You can do it at the end. Someone will come over with a microphone to take your question. If you're on the webinar, I think you've got instructions on how to submit questions, and we'll make sure we respond to all of them. So with that, let me turn it over to Kelly and Joel.
Thanks, Bob, for that introduction. Today's topic is top privacy and data security trends, although I suspect a lot of you have come for the GDPR. But we didn't want to jump into that as a little appetizer. We thought we'd start with some data security trends from 2017, projecting into what we see happening in 2018, especially around breaches and data security from the U.S. perspective. So we're going to start there and then move into GDPR, which will touch on both, of course, privacy and security. So we decided to start by pulling together some information about data breaches in 2017. This is pulled from the Verizon Incident Report, which is put out at the end of every year and kind of summarizes publicly available information about data breaches. And the thought here is that if you know from where threats originate, you might be better able to head them off at the pass. So, of course, you can kind of see what's here and read that for yourself, but we wanted to highlight in the who's behind the breaches part of the slide that, again, the vast majority of breaches tend to be perpetrated by outside parties, although a significant percentage, again, continues to be internal actors. On the right of the slide, what tactics are they using? We thought this was especially interesting because, as you can see, 81% of breaches can be traced back to stolen or weak passwords, which, of course, that was what was behind the DNC breach and a lot of other high-profile breaches. and it's something that organizations can engage in some self-help on. So while it might be sophisticated Chinese hackers getting a lot of the headlines, the way that they come in is through an unlocked door or a loosely barred door in the vast majority of cases. The other thing we wanted to point out from this slide is the percentage of breaches that include malware. And I think the high-profile incidents here have involved point of sale at hotels, restaurants, and retail outlets, which likely is not relevant to this audience. But I know that we've assisted a number of organizations who have had malware breaches that affect their websites, that affect vendor services that they've employed. So, you know, you can sort of think, oh, point of sale, not relevant here, but malware is something that more broadly affects, it plays a role in a lot of the breaches. Okay. Oops. Okay. All right. So this slide talks about phishing attacks. Again, stats taken from the 2017 Verizon data breach report. Phishing attacks are an oldie but a goodie because they work. Small businesses, as you can see, are especially vulnerable to this type of attack. And what I thought was really interesting was that 1/4 of organizations affected by a phishing attack will be affected again. So I think if you've ever been through a breach incident or data security incident, of course, there's the immediate rush to cure the problem, to stop the bleeding, to take care of any incident response. But it's the after action that really can help protect your organization going forward. It's that lessons learned part that a lot of organizations skip because you've already, you know, engaged your resources and why. We've learned from this one, but you have to really go through that lessons learned exercise to help your organization understand how to better protect themselves in the future. Joel, I think you Catholic Relief Services may have some experience with this.
Yeah, just a couple of questions for me to baseline everyone's sort of relationship to this topic. How many of you get phishing email at least once a week? Just a raise of hands, maybe even once a day. How many of you are aware of a breach, say a significant event, security event that's happened within your organization in the last 12 months? Okay, a few of you. It's likely that the majority of your organizations have had some sort of event, even though you may not know about it. I believe in the same Verizon report, most breach events, most infiltrations go undetected for months, 6+ months, before an organization actually is made aware of the breach. We had one just a few months ago, back in September. We didn't take us 6 months to detect it, but it was absolutely perpetrated based on a phishing attack. And I figured to dispel some of the hypotheticals around this, it might be useful to explain sort of how we were breached and how we had to respond and what the sort of longstanding impact of that was, and staff churn and investigations post the event. So to give you a sense of the types of attacks that each and every one of you is susceptible to and is likely being subjected to almost every single day. So back in September, a member of our staff here in the United States received an email from a trusted church partner. And it appeared to be a link request or a sharing request from DocuSign. I suspect many of you use that service. The individual clicked on the link. It said that they could use their Office 365 credentials, which is a service that we use, to access the link. He clicked on it, filled out his information, and it didn't work. And he figured, I don't have time to worry about this right now, I'll step away. What had actually happened was our church partner, email had been compromised, and the person had phished all of their contacts, including one of our staff members. Our staff member had inadvertently handed over his Office 365 credentials to that attacker. So note that the payload, there was no payload. It wasn't a compromise of the device. It's purely a credential sweep. So they handed over their credentials. That person sat dormant in our environment for about 24 hours, gathering information, messing around with that person's account, copying our address book. And about 24 hours after having gotten into our systems, spear phished our entire organization, every single person on our staff, and every single external contact that this individual had in their address book, 8,000 people approximately. And that touched off a sort of cascade of further compromised accounts. It took us about 48 hours, 2 full days, with something akin to a war room, a group of people sitting around the table with a number of others on the conference call for the better part of 2 days to get this under control. And in like the tally at the end of it is we lost control and had to regain control of about 22 email accounts. Those accounts phished or spammed innumerable addresses, sort of compromising the integrity of the crs.org domain, and certainly caused a whole bunch of churn in IT. It took us about 48 hours to get control. Lost a third of staff time. A lot of key employees were targeted, ended up losing access to their accounts. And I think because of some of the things that they did, we lost somewhere in the realm of 5,000 to 10,000 emails through email forwarding. It's of note that in these attacks, it's fairly commonplace for these attackers to put forwarding rules, such that you don't even know you're getting email anymore. The email is being forwarded to some third account. So we had to actually go and look at every single one of the headers of those emails to evaluate whether or not we lost anything sensitive. We didn't, but that took an enormous amount of time and effort. Had we looked for that, had we had a documented response plan for that type of an event, we would have saved ourselves about 24 hours. We've noticed those rules in place 24 hours earlier would have significantly mitigated the amount of email we lost and saved ourselves a bunch of time. I guess moral of the story is, if you think that you're not susceptible to this stuff or you're not being targeted, it's not true. I mean, we are all being targeted, and since we were sort of compromised, we've seen a huge uptick in phishing because we've been shown to be vulnerable. I have it on fairly good authority from other members of NetHope, which is a INGO consortium, that the same thing has happened. When they've been shown to be compromisable, attacks increase. The attackers are talking. And it ends up being harder and harder and harder to stay on top of things. And secondly, assume you're going to be breached and prepare for it. Had we had a fairly well-documented process for dealing with a compromised email account, we would have saved ourselves a whole lot of additional work. Probably resolved the issue in half the time it took us to do it in actuality. And that's something we've done kind of post-mortem on that particular incident, is document an approach to dealing with these in the future. So.
I think something that Joel, you said was really interesting, that you had to go back and look at the email headers of all of the emails to see if there were any sensitive data. And that's something that we've assisted a number of clients with who have experienced similar incidents. We had one where they had compromised the email account of their HR manager, and there were social security numbers, they had driver's license numbers and copies of folks' IDs, and it required, sounds like you guys did this internally, well, they had to pay Venable to actually review thousands of emails one by one to look for data that potentially requires notification under state law. So the costs of that can be, quite significant and really challenging. I think something else, one of my favorite anecdotes is I was talking to a chief information security officer of a major media company, and he had been a CISO for a long time and had been in security for, 2+ decades. And he said, no matter how sophisticated I am about these things, if you want to compromise our network, send me an email, make it look like it came from my daughter and has an attachment called, grandkids, that looks like photos of my grandkids, and I will open it every single time. So it only takes, I think, a little bit of internal knowledge, and it's pretty easy to game folks with phishing attacks. I think a lot of times where they fail is because the English is so bad, right? It's so obviously poorly put together, but to the extent that there's a little sophistication, they really work. We helped a number of companies and organizations last year, and these things go in waves. There are trends, and the big trend last year were W-2 forms. They targeted small companies. It always looked like the CEO or somebody was emailing the HR manager, and it seemed to work in smaller companies because that's where that wouldn't be uncommon for a CEO to reach out directly and touch someone in HR. And they would say, I need copies of everybody's W-2 forms. And they zipped them up in a file. They might have 30 employees or 50, sent them back, thought nothing of it in January or so. And then when folks started filing their taxes in March and April, they found that tax returns had been filed in their name. And this was something we helped 3 or 4 clients with last spring. I don't know if that one has kind of reached consciousness and that won't come around again this year, but something to look out for. So who knows what the big scam of 2018 will be, but there will be something.
It's perhaps even worth noting that our organization has invested a fair bit of time and resources into awareness training, which I would advocate very much for each and every one of you doing. So, we spend at least an hour with every single employee through computer-based training, educating them on phishing and incident awareness and operating safely online. And even that effort doesn't sort of protect you completely against these types of attacks. We did a recent baselining using simulated phishing, which is basically us attempting to attack ourselves to see whether or not we'd be successful. And even with a full year of training and awareness under our belts, we're still at about 15% response. 15% of the staff that were in that particular test responded by clicking and entering credentials. So that's far lower than it was, but it's still not great. We have a long way to go to get that to a place where we are significantly mitigating the risk of our employees, because for all intents and purposes, they're the weakest link that we have. We could spend infinite amount of money on technology. If all it takes is somebody to send a fake DocuSign link to somebody for them to give up their credentials, there's no technology really that will completely protect against that.
Question.
How large is your organization? How many employees? Oh, I'm sorry. How many employees are you talking?
Catholic Relief Services it fluctuates based on disasters in the world, but somewhere between 6,500 and 7,000 people globally.
Okay. So we have an organization of 30, and we've had all of the things that you're talking about, including a FedEx thing, which sent somebody clicked on it thinking it was a FedEx package, put in all the information, and it crashed all of our system. So we actually have just 30 people, and we now have everybody set up that if it doesn't look right, they send it to me or to our IT and say, is this real? Should I take care of this? But I also had the DocuSign. I'm the only one who signs documents, and I was waiting for one, and that came through, and I started to do it, and I went, this doesn't look like the normal ones, but 6,500 I can understand. That's really hard to get 6,500 people aware.
Yeah, in 95 countries. I mean, we're all over the place.
Yeah.
But yeah,
we're 30 in one office. Yeah.
In your case, you employed a training program, something of awareness.
Well, actually, the FedEx thing was the training program because it crashed everybody. And so everybody became very aware. We had the W-2 thing that came in, that when it came to our HR person, she sent it to me and said, why would Bo be asking for this? And I said, this isn't her. So everybody now questions if they get something that doesn't look quite right, they never click on it and they just send it and say, is this right?
So you've done education through communication.
Exactly. Mm-hmm. Yeah. A disaster helps.
Yeah, it does. Unfortunately, it often is the call to action, but it would be nice if it didn't need to be.
Yeah, but again, I'm 30, you're 6,500,
yes.
So yeah.
Thanks. Okay, so moving on from phishing attacks, another significant source of vulnerabilities really comes from vendors and third-party software. Obviously, some of the examples we've talked about in the room, you can try really hard to button down your own staff and your own internal processes. But of course, every organization is heavily reliant on third-party vendors to provide a lot of critical services. This really does present a particular vulnerability. This, for example, was the way that the Target breach happened. It came in through their HVAC vendor. We've produced a couple suggestions here regarding vendor management, and this, of course, sort of common sense things to really look at the security practices of your vendors and be aware of vulnerabilities that might threats to your network that you can sort of work with your vendor and pass along to them to help them correct any problems.
Kelly, Joe, let me ask you a question, because I know this is something we've dealt with, frankly, at Venable, is as more and more employees are using their smartphones and linking in, or their iPads or whatever, linking into the systems of the company, what does that raise special issues or concerns? Or
well, you're referring primarily to the sort of bring your own device paradigm, right? it's certainly an issue for nonprofits, and a more difficult one perhaps for us to tackle because of the resource constraints that we're under. We tend to not have the resources available to do many of the mitigations that a for-profit might be able to employ. And we also tend to be a little bit looser with our security policies and what can and can't be used, where it can be used from. I know with CRS, part of what makes us the organization that we are is our ability to be adaptable and nimble. And the demands that are put on me by my organization is to make things basically completely open from anywhere, unless there's a really darn good reason not to. And that includes the ability to access things from personal devices. So, yeah, I mean, with bring your own device, the only thing you can really do is attempt to put in some reasonable policies for how you keep track of what people are and aren't using, and to attempt to employ some sort of enforcement mechanism like AirWatch or Mobile Iron or Intune, some sort of software that if you are allowing people to use their own devices to access your resources, that you have some control over the security parameters on that device and the ability to claw back that data if they, terminate in some way that is, not amicable.
Okay. On the theme of vulnerabilities, I think this is something that's been in the news, and we just wanted to highlight it. There are these chip flaws that have just come to light in the past few weeks, which essentially, as I understand them, render every PC in existence vulnerable to a particular set of threats. There are some patches so far, and there probably will be more, but this is a really good reminder to plug known vulnerabilities where you can, to employ patching, firewalls, whatever safeguards you can put into place, especially when something, is high profile and comes to light. So I know clients all the time, the resources are a problem and a concern. You obviously can't attack every vulnerability that comes up because there are potentially thousands of them, but some sense of high profile ones that affect your critical systems, definitely keep an eye on that list and sort of try to triage and treat your priorities appropriately.
And I suspect even an organization of my size, which is, as I said, more than 6,500 people, we don't have a huge IT department. We have to leverage our partners, vendor resources, to help manage this stuff. In the case of Meltdown and Spectre, which do impact every single modern computing device out there, we're heavily reliant on, we have a managed security service provider who does quarterly vulnerability scanning of our network, on them kind of informing us what to and not to patch, because in many cases, these patches are systems and performance impacting. So we may choose not to in certain circumstances where CPU cycles are really important and speed is really important. But for those things that are service related, we have very intentionally moved more towards software as a service and external hosting providers, and not doing these things by ourselves because they're not core competencies. We just have to be really intentional about our relationships with these vendors so that we are asking them for what they're doing and kind of holding them to their end of the bargain to make sure that we remain protected. In the back?
There's a question back.
My understanding of the Meltdown and the Spectre situation, somebody smarter than me is free to correct me on this, but my understanding is that the hardware flaws in these chips were born out of the manufacturers trying to balance speed and opting out of security. Everybody wants more speed, and they had to lessen the security because of that. Because this is a hardware thing, it's going to take a long time to get all these devices, the CPUs redesigned and then replaced, of course. It's going to be years for many companies. And the patches that are being offered right now are software patches. That's the most expedient way to try to address this. But in terms of managing expectations of the users, it could have a significant impact on the speed of the processors because of the software patches. And that's just something I think is important to be aware of and to convey. If people are already telling me, oh my gosh, everything is so slow, well, it could get slower.
Yeah. Anything running Windows 7 or 8, especially, and basically any processor pre-2016 will see a 15 to 20% decrease in speed the minute you patch Windows or Mac OS or Linux. Yeah, it's a huge issue, and I don't know that anybody has a real handle on it. I think we're all sort of just trying to figure it out. And for us in this room, that often means is sort of staying in constant contact with what your vendor's plans are for dealing with this, and making sure that, to the extent that you have a voice in that it's consistent with how you want to approach it.
Joel, you mentioned vulnerability management, and you might choose to not remediate certain vulnerabilities because of speed and performance. Do you document that in any way?
Yeah, we have, with our managed security service provider, the vulnerability scanning they perform has a history embedded in it. So if a vulnerability is discovered in one quarter, it remains in our report, and we can append notes to it for why it continues to be there. Because if it is there for a couple of months, my CIO will ask me why. But yeah, I mean, we don't often accept them. The only times we generally accept them is if there is a business case to allow that particular type of functionality to exist. For example, with Spectre or Meltdown, if we were doing data science, high throughput data calculations on a device that was air gapped, for example, meaning that it wasn't on the network, we may say it's vulnerable, but the likelihood of it being compromised is so low, we can't afford the 20% decrease in speed, so we're gonna keep this unpatched. Generally, the reason we don't patch something is because of a compatibility issue.
Right.
It's old, we need to get rid of it, but it's legacy, and we can at the moment, and we may have to accept certain vulnerabilities and do other things to sort of segregate it in the network to limit the potential risk, rather than all-in-out patching.
And I think whenever we get into security standards under the GDPR, U.S. security regimes that look at reasonable data security, I think recording those decisions and being able to provide a record of why certain vulnerabilities were left open is really important, to have those processes in place to help support, the conclusion that what you're doing is reasonable. Okay, so just to overlay the law onto this briefly, of course, I think everyone in the room is aware that 48 states have breach notification laws. And, helping clients through this, where I sit, what's interesting is that continued failure of the federal government to act in the breach notification area has really pushed this to the states. States continuously update these laws, and they're updating them in ways that are not favorable for entities that have to provide notification. The most common updates we see, and there's usually anywhere about a half dozen states every year that update, they tend to expand the definition of personal information to include more and more data elements in that definition. A lot of the states are adding timelines for notification, so that reasonable or most expedient time possible timelines are becoming fixed timelines. Delaware, the example there, if they added a 60-day timeline, for example, to the notification that has to be made. And Delaware is following, I think, what is the newest trend in state laws, which is to add affirmative security requirements under state law. So we might not have general data security from a federal level. Instead, we have HIPAA and Gramm-Leach-Bliley and these kind of sectoralized laws. But the states are filling the gap by requiring general data security over, personal information kind of generically defined.
So are the states, out of curiosity, are they pointing towards NIST, for example, as a reasonable security framework in the U.S.?
They tend not to specify.
Okay.
Good question, though. Okay, so we wanted to end with something positive before we travel over to Europe with some best practices. I think we've touched on a lot of these in the discussion so far, and I think what you'll see is that the GDPR tends to codify some of these into actual law, but these are still, in most cases, best practices in the United States. Things like data minimization, controlling access, authentication, because we saw how many of those breaches are caused by compromised passwords, and of course looking at your vendors and service providers.
So just thinking about the way we've approached information security, it's an enormously broad and deep topic, a domain that you could spend infinite amount of time and infinite amount of money on, neither of which we're blessed with. We have very limited resources time-wise internally. We often have very limited resources financially to enact change in this area, yet we're under many of the same attacks and requirements of other organizations in, say, the for-profit sector who do have more time and money to address these. When I first started out in this sort of on this path a couple of years ago with CRS, the approach was twofold, and it was to attack the problem from the front and from the back. The front being training. If the most vulnerable part of my organization was the people, it seemed to me the best use of money, when it tends not to be a terribly expensive amount of money, would be to train, to raise the level of awareness, to make people understand that these things are happening to the organization and to them, and that their actions have consequences. So one of the first things we did was awareness training and simulated phishing. And I would suggest, if you're not already doing that in your organization, that you consider doing so. And there are a lot of very reputable training vendors that have very reasonable pricing for nonprofits to do that. And on the back end, breach preparedness and response. Consider documenting and drilling how you would respond to a certain set of breaches that you'd expect to occur. If you had a phishing event happen and you lost personally identifiable donation information of your staff or your donors or the people that you're serving, what would you do? How would you approach it? Document it, figure out who gets contacted and when, and then sit down around a table and drill it. If you have the training up front and you know what to do when you do get breached, which is going to happen, you're all going to have a breach event at some point in the near future, you'll be in reasonably good shape, and you can, through additional investment as time goes on, sort of close the gap between the two through technical mitigations, things like two-factor authentication and bring your own device, technical implementations that will limit the risk. But start with training and start with preparing yourself to respond to the breach, because you're going to get breached. It's going to happen.
Kelly and Joe, let me ask you a question. Do you have any thoughts on when a breach does occur? You've got various constituencies in a nonprofit. You've got your internal, your employees, and you've got your external, your donors, your beneficiaries. Any thoughts on how to communicate the breach internally, externally? Or is there any science to this or art to it?
I think one thing that I've noticed in the years that I've worked on breach response is that I think because breaches have become so common, there's less reluctance to be really candid, open, and to communicate quickly than there was in the past. So, of course, reputational concerns are a problem. Everybody worries about that. But kind of your outward-facing relationships take less of a hit now because everybody's been breached, right? So we sort of advise to communicate faster rather than more slowly, because the first question you're going to get is, you've known about this since when? And it's easier to answer that question if the answer is, well, we found out on Friday and it's Monday, versus we found out 6 months ago that your social security number might have been taken, right? So I think also in breaches that involve HR information, we've seen a move towards prophylactic notice. So because of the circumstances, you might not be required to provide notice under the law, but it's your employees, you want to do right by them. A lot of organizations will provide notice anyway with the credit monitoring and the other pieces that have become common.
Yeah, I guess two things to add. One, if you're documenting a breach preparedness plan, the decisions on who to engage, when to engage them, and when to make the decision to go external would all be documented in that plan. The criteria by which you decide, okay, it's time to go ahead and notify in our case, a donor or a partner or a regulator, would all be documented in a plan related to breach of beneficiary data in one of our programs overseas. In another recent event that happened a few months ago that I will share when we get into the GDPR stuff, the decision to be open early with partners, both local and international and regulators, I think probably saved us a lot of headaches. Once we had a general handle on the situation, explaining what happened, what we were doing, and how we were going to ensure that the likelihood of this happening again was going to be sufficiently mitigated, stopped almost all the questioning in its tracks, because we demonstrated that we had a handle of the situation and that we were taking reasonable steps, and that gave confidence to our partners.
Okay. And I think that these points go to what we're calling security by design. We've talked about training and things you can do to raise awareness within your organization. And these are important steps that, as Joel pointed out, in a lot of cases don't take a lot of financial resources. You may be able to, training is a lot cheaper than penetration testing in most cases. And it really does help kind of bake security into your services. Okay, so you came for the security, stay for the GDPR. Time for, let's move across the ocean to Europe to talk about the forthcoming General Data Protection Regulation. It's definitely been the top of mind topic in privacy and security as well. I think starting last year and certainly up until the May 25th effective date. So I'm just curious, how many of you work for organizations that have determined you are subject to the GDPR? Oh, there's like no hands in the room. Interesting. Okay, so, okay. Well, maybe.
Is that because you haven't done an assessment, or you know definitively that you're not, or they've decided definitively that it doesn't apply to you? Anybody?
So assessed and decided it doesn't apply. Haven't done it.
Okay.
Or this is the first you've ever heard of the GDPR, which would join the club. So.
Okay, well, we're going to spend a little bit of time, just a brief overview of the regulation, and then talk about some, myths and legends about it, and hopefully try to dispel them. It's complex, so we certainly welcome questions throughout. But okay, so let's start with what the GDPR is. It stands for the European General Data Protection Regulation, and it will replace the current EU data protection law, which is known as the directive that's been in effect since 1995. So this is a major sea change of a law that's been in place for 2 decades. For any of you who have dealt with European law before, they come from it from a really fundamentally different place than we do in the United States. So we have this sectoral specific framework where we regulate health data with one set of laws, and financial data, children's data. We have these different silos. The European mindset is different, and it sees privacy as a fundamental right. Data belongs to the person with whom it's identified, and that individual then has rights over their data. And these rights are enshrined in the European Union Constitution. So the directive, the law that's in place right now, is kind of a high-level set of these principles and rights, but then it was up to individual member states to implement them through local law. And this led to disparate laws. So in the UK, it was a little more business-friendly, US-friendly. In Germany, for example, it was a stricter law. The GDPR looks to replace that. So it will be one law across all European member states, as well as the states that are in the European Economic Area, which are like Norway, Liechtenstein, and another country that I can never remember. And the law will be a single standard to apply across all of Europe. It imports from the directive these fundamental rights, although it expands those rights in a lot of cases and adds some additional specificity for how individuals are able to exercise them. But it adds a number of new obligations, including transparency, which means privacy policies have to state specific information, and there's over a dozen elements that have to be added to privacy policies. It adds accountability, which are a number of record-keeping obligations, the requirement to have, in a lot of cases, a data protection officer to do privacy impact assessments of any activities that you're doing. It adds, for the first time, data security and data breach notification in Europe. It has a whole new enforcement regime, which are called supervisory authorities. They will be established in every country and will enforce the law, and they will work together to bring complaints across country borders. And it keeps in place rules against international data transfers. And I think as we go through, we're going to sort of touch on a lot of these different topics. So just a couple core concepts, and these exist in existing law and have been imported over to the GDPR. Again, we think of personal data here as a list of enumerated elements. It could be your fingerprint, your name, your email address, a phone number, medical data. Personal data in the EU is any data that can be related to an identified or identifiable natural person, full stop. which means that anything that you can trace back to a person, even if you don't know that person's identity, potentially is personal data and is subject to the rights in the GDPR. And if you look at the definition of identifiable person, it's anybody who can be identified even indirectly by reference to, all these things are personal, identifiers, including location data, online identifiers, which would include IP address, cookie identifiers, RFID tags, which means that a lot of online tracking, which we think of as anonymous and done for marketing purposes in the United States, that's all considered within the personal data regime in Europe. There have been decisions that say things like the raw data that comes from a Fitbit tracker is personal to the individual. So it's just a sense of how expansive the definition is there. And it also categorizes entities into two buckets. So there are data controllers, just any legal entity which determines the purposes and means of processing, and processing is any operation done to data. It could be something passive like data storage, transfer, or something more active like actually using the data for decision making. And then processors are only functionaries who carry out instructions of the controller. You have to fall into one bucket or the other, and which bucket you fall in determines what your obligations are under the GDPR. So a processor is usually just a dumb pipe. Cloud storage provider is kind of the perfect example of a processor. They have lesser obligations, but controllers have, extensive new obligations under the GDPR, and we will talk about those.
One quick example on how this gets sort of muddy. NetHope, I mentioned them earlier, the consortium of the IT departments of 51 or 52 of the largest INGOs in the world, in part of the Syrian refugee response in Greece, deployed somewhere between, I think, 20 and 40 Wi-Fi hotspots along the path of migration, and decided that they wanted to take the data from each of those hotspots and attempt to sort of map the flow of migration across the path. They went and they grabbed the information and began to consult legal on it, and determined that MAC addresses, which are the hardware address for a network device, was an identifiable item. And since these individuals were in the EU, granted this is before GDPR is in effect, but there was enough concern about that being identifiable and consent not having been gotten when somebody connected to that network that they had to delete all the information. Couldn't do any of that work that they'd planned on doing because they didn't get consent to capture what would be considered a personally identifiable data point. So it's pretty broad.
So here, the 7 data protection principles are sort of the heart, what I think of as the heart of the GDPR. And even though they're styled as principles, they are implemented throughout with specific obligations. Just to expand on these a little bit to draw your attention, the first one, all personal data processing must be lawful. Okay, what does that mean? It means that there are 6 recognized bases under which you can lawfully process data in the EU. And if you don't fall within one of those 6 bases, you can't process that data, period. Processing means collecting it, storing it, holding it. So the mindset that we often have, which is we have a database, we've built it up over decades in some cases. Some of these contacts in them, they may no longer be active, but we keep them anyway. You do not have a lawful basis in Europe to hold that data anymore, and it has to be deleted under European law. Moreover, it's not enough to say, oh, I'm sure we collected it under a lawful basis at the time. Now under the GDPR, you have to be able to document that. You have to be able to point to every record you have, what the basis for processing that record is, and you have to publicly disclose the basis for that processing. And to the extent that you want to use that in a way that's incompatible with that stated basis, again, you can't do it absent, going back and sort of re-permissioning that data. And we'll talk about what those half dozen or so basis for processing are. Principle 3, data minimization, and 5, storage limitation, again, go to this core concept that the amount of data you have to have has to be sort of as minimal as possible, has to be tied to an explicit, specified, publicly disclosed purpose for which you are storing that data. And if not, the idea is you are supposed to get rid of it. Really, data minimization, I think of as one of the kind of the most fundamental concepts, because and I get this question all the time, but like, they don't want us to have it. No, they don't want you to have the data, and they want you to delete it if you're not actively using it or holding it, pursuant to a lawful purpose. And again, that also goes to 2, purpose limitation, which is that you can collect it only for specified, explicit, legitimate purposes. And there is a menu of what are considered legitimate purposes in Europe. It's not enough to say, as we would say in a U.S. privacy policy, that we collect data, for other business purposes specified at the time of collection. That's not good enough anymore. You kind of have a choice of things that you can collect data for. And then, of course, they have this notion that data has to be accurate. So there's an accuracy principle, also an integrity principle, which now they've used to also add data security, and then accountability, that all of this has to be documented internally. Okay, so I had mentioned what the rights of the data subjects are here, the rights under the GDPR. The new ones that will come into effect in May are data portability and the right to erasure, which is sometimes called the right to be forgotten. How does this work? So you are a European individual. I have a right of access, so I can send your organization an email and say, hello, this is my name. Please tell me all of the data you have about me. And you have to tell me. And then I could say, I would like a copy of that data, please. And under my right of data portability, you have to give it to me in a commonly used machine readable format. You have to give me an export of that data. And keep in mind how broad the definition of personal data is. So it's not enough just to give the record of my, name, address, and donations that are in the CRM. But if you have been collecting data that's tied back to me via cookie, because I've visited your website and clicked on different articles or stories, or you're tracking the fact that I've opened emails from you, all of that data is personal to me, and I'm entitled legally to a copy of all of that data. And then I could say, you know what, I object to you continuing to hold that data about me. And under my right of objection, you have to stop my data processing. I can also say, I'd like you to erase it, please. Forget I exist. And again, that's another right that European individuals now have. And restrict processing is also very similar. So you can say, well, I would like you to no longer process it for marketing purposes, but I would still like, for you to process it, for example, if we have transactions for donations and stuff. So they have some flexibility as to what processing operations they can perform. They have control over that. Okay, so, yep, question. Mm-hmm.
Thank you. I have a question on website access and what that would look like. Could you preempt something like that from happening if you put on your website a request so that before someone used your website, they say, I understand that, but da-da-da-da-da.
Understand that, like,
that we will be collecting, your clicks or your IP address or whatever it would be that would be a disclaimer from our side of the fence.
Well, it doesn't get you out of, having to extend those fundamental rights to that individual. They can't waive them.
Okay, so they can't.
You could get consent to do those things before you began collecting
but
information.
It wouldn't make any difference if they came back later on.
They could revoke those rights.
Right. I haven't, but they couldn't come back and say you've done this to us or make.
Right.
That's right.
Okay.
Right.
You could also choose, if they just said that they didn't want to do those things, to not interact with them at all. I don't think there's a right to service, right? If they don't want you to process data and that's part of what you do. If somebody says, I don't want you to process my data, you can say, well, then I'm sorry, you can't use our website.
Not exactly.
No?
So you actually can't condition services anymore under the GDPR on them providing personal data. So if you have a mobile app and, you collect data, but it's offered for free, you are supposed to offer a version where they can reject the data processing but still get the service. True. I'm getting some angry looks. Okay, so let's talk about transparency. This is one of the new rights, and this goes to your privacy policy. So privacy policies need to have specific elements under the GDPR. I think we'll unpack some of these as we go along. You do have to explain all of these fundamental rights in your privacy policy. Another one is you have to explain all your data retention periods. So you have to full out come out and say, you know, what you're collecting the data for, what the lawful basis for that data collection is, and then how long you hold it, and you have to meet those conditions. I think as we work with a lot of organizations, what we're finding is really challenging is that CRMs aren't set up this way, right? So you have a big pool of data. It's come into your organization in a number of different ways. You know, you do events and conferences. You have folks who have come to the website and signed up, folks who have done donations. You have a lot of different ways. You don't know where that data has come from, how it was permissioned. You might not know how long you've had that data. And as you go through the exercise of trying to parse that out and figure out, okay, this is stuff we're no longer supposed to have. This is stuff that's still good. The records just aren't robust enough to support that kind of determination. And I think that that has been a real challenge in implementing the GDPR. You know, you have to explain to folks how they can withdraw consent for processing. You also have to advise them how they can file a government complaint against you if they're not pleased or they think you violated the GDPR. And if you're doing any automated decision making, this is something they're very concerned about in Europe. So any kind of machine learning to make a determination about somebody, like, you know, you crunch your data and you're like, okay, these are certain donors that we want to go after for whatever reason. You have to disclose what logic you're using in your privacy policy publicly. And also, if you are receiving data not from the individual, so purchasing data through lists, you have to provide some transparency into where you're getting data when you're not getting it directly from individuals. Okay, so into the myth or fact section. It sounds like some, oh wait, we have a question.
These GDP laws, kind of PR laws, kind of extend into the legal and the law enforcement agencies.
Law enforcement, so I think the question was, does the GDPR extend into law enforcement agencies? Yeah. So this is all for private industry. There's a whole separate regulation that governs governmental data collection and such. So it doesn't, essentially. Okay, so our first myth, and I think this goes to a question that was in the room to the extent that you haven't analyzed whether it applies to you, is the GDPR doesn't apply to my organization because, and I've heard every flavor of this, so we don't have offices or employees in the EU. We have really, you know, as a percentage of our membership, our EU membership is very small, or, you know, because we're a nonprofit. So let's talk about who does the GDPR cover. The GDPR, of course, covers to anybody who has what they call an establishment in the EU. So if you have employees there, or you have an office there, if you're using contractors there, it applies to you, even if you are based in the United States or if that EU office is very small. If you don't have a presence in the EU, the GDPR applies in two cases. So either if EU residents' personal data is processed because you are offering goods or services in the EU market, or if you are monitoring the behavior of individuals online. To unpack both of those prongs, how do you know if you're offering goods or services? So there's some functional tests in the regulation, like does your website have local domains? Like do you have a .fr or a .co.uk domain? If you have prices on your website in euros, if your marketing materials promote EU connection, so if you have folks at an annual meeting, you know, posed in front of the Eiffel Tower, that's potentially offering goods or services. Do you host meetings there? Do you partner with organizations there, actively seek them out?
Let me ask you a question. What if, like most nonprofits, on your website, on the nonprofit's website, there's a contribute button? And it's on the internet, so it's available everywhere.
Yeah, right.
So anybody could go on EU, wherever, and contribute. Does that implicate this?
No, not necessarily. So it's clear that the mere offering of a website that's generally accessible from anywhere in the world does not meet the test of offering goods or services. Although I think you would have to look at where your contributors come from. And even if you don't have, the local domain or whatever, if 50% of your donors are coming from Europe, then there's a good chance that you are offering some kind of service in the EU market or trying to take advantage of the market in some way.
So a sporadic gift that comes in from Europe would not trigger this?
That's correct. That's correct. Right. But if you're having your annual meeting there or once every other year, it rotates around and it's in Europe, you are likely offering there. And they are clear that services include it's not monetary.
My nonprofit has an annual conference here in Washington every year. And most years we have participants who come in from Europe. And so, of course, they're paying a registration fee. They're taking advantage of a 3-day conference. Would that be considered goods and services, and would they then be applicable under this coverage?
So it's whether you are offering those goods or services. So it depends how they find you. Again, in Bob's example, if they just, come across the conference and they sign up and they come, no, you're probably not offering. If you're actively reaching out to partner organizations to promote it in Europe, then you are likely offering services there. It's a functional test.
Quick question. What if you have a dual citizen, U.S. and EU?
Oh, does the GDPR apply?
Correct.
Where do they live?
If they live in the U.S.
Then no, it doesn't. So the GDPR applies to the behavior of EU individuals while they are in the European Union. And it's a question we get a lot. So if they move to the United States or they're on vacation and they encounter you, then no, it doesn't apply. Oh, one more. Mm-hmm.
International members who want to participate in, first of all, they become a member of your organization. They want to participate in some of your programs. They may buy some product from you. Are they subject? Are we subject?
Again, it depends how they found you and whether you are offering your services in a way that's designed to appeal to EU residents. Yeah. That's another way to think of it. I also think it's really important to look at the data you hold. So it's almost like the data prove the test. Again, if it's a significant percentage of your membership is EU, you can say, well, we don't have marketing materials that are translated into local languages, but something is happening there where it's more than a insignificant or incidental percentage of folks who are just finding you on the web, and it's important to kind of run that down. I think something else we've done for a lot of organizations is once they've isolated, what their contacts are, to the extent that you're not interested in offering goods or services in the EU, there are things you can do to isolate yourself. For example, deleting that data, again, if it's not significant, and then making sure that language on your webpage is clear. So there are things you can do to kind of nudge yourself one way or the other, depending on what future plans are.
That's interesting, because we were just having a conversation about perhaps translating some of our promotional materials into different languages and different parts of the globe, and
So it's something to consider.
Yeah,
right? Because you may kind of nudge yourself over the line in the EU by doing something like translating your materials into local European languages and trying to distribute them in that market.
Right. Okay.
Can I just push that question a little further?
Sure.
If you have people who just find your conference on the web and attend from the EU, but then the next year they're on your mailing list for invitations to the next year's conference, would that bring you into the offering goods and services category?
Possibly. And, when I get questioned on these points, remember, the purpose of the regulation, again, is to sort of protect these fundamental rights that EU individuals have. So it's meant to be read expansively and to try to, protect EU data whenever possible.
So it might be helpful to sort of articulate sort of our thought process and why we think we are, CRS is subject to the GDPR in some limited circumstances. When we started to think about this, we broke it down on 3 domains: staff, donor, and our beneficiaries, the folks that we serve. On the staff side, we have, we believe, fairly limited exposure. We do have a handful of international telecommuters who are European citizens working out of the EU. We have some programming in Greece and in Cyprus, and employees that work in those particular programs. But it's a fairly small component of our global workforce. So there is risk exposure, but it's not enormous compared to our entire organization. On the donor side, we have sort of an insignificant number of donors that gave addresses at one point or another in the EU, but it doesn't rise to the level of significance, and we don't do any active marketing. We're a US-based organization. We have EU counterparts as part of the Caritas network, like, for example, CAFOD in the UK and Procra in Ireland. They do marketing, donation marketing, donor marketing in those countries. We don't, but we don't not accept money from somebody regardless of where they're from. But again, fairly limited risk. For us, the majority of the risk is in our programming, because we do support, do have programs that are supporting Syrian refugees in Greece. We have a reasonable expectation that those would be covered entities in the GDPR, and are dispatching individuals from our organization to perform an activity that's coming up as one of the things that'll be talked about, called privacy impact assessments, to assess more specifically our risk there and come up with mitigations, probably inclusive of roles and responsibilities for notification, mitigations to limit risk, changes in the way we do consent with those beneficiaries. But we expect that at least those programs in those two countries, Cyprus and Greece, are covered. We're also looking at this sort of a longer term. We operate in somewhere between 85 and 95 countries right now. And most of those countries are in Africa and Asia and South America, and they don't have very substantial privacy regulatory regimes. But that's changing. Certainly in Africa, we are seeing a number of laws be proposed in legislature that are ostensibly copy and paste of the GDPR. So we are looking at this sort of as a bellwether for the way the majority of the world will begin to move in privacy, and that we sort of need to get right by it, not only in Europe, but throughout the world, if we expect to be even remotely compliant in the work that we do.
Yeah, and that's a really good point. There's the U.S. approach, which we've talked about, and there's the European approach. And to the extent that more countries develop privacy legal regimes, they are tending to follow the European approach, not the U.S. approach. Question? No. No, the question was, do we see the U.S. following the European approach? No. I think it would take a real, it comes from a very fundamentally different place, and European history and fascism and collecting data about people. It just comes from a real fundamentally different place. Okay, and I should mention too, there is no exception for nonprofits under the GDPR. You are treated as any other commercial enterprise. Okay, so Joel had mentioned consent data collection, and
hello. So,
I'm sorry.
Sorry, just a quick question. What about Asia?
Oh, well, so South Korea and Japan the European Commission does something when they look at the laws of another country and say whether they're adequate, which means equivalent. And it's expected this year that South Korea and Japan will get adequacy determinations. So those are two countries that will have their own versions of the GDPR in place. China has recently put some data minimization and data localization laws into effect. So again, following kind of this trend, yeah, Asia is moving towards Europe, but is not unified the way that the European Union is. Yep. Question?
On fines,
Sure.
and the fact that, they're based upon, is it revenue or revenue?
Mm-hmm.
And in the nonprofit world, how would they fine
So the question was about fines, and we probably won't get there with the timing, but penalties, the civil penalty for violation of the GDPR is up to 4% of your annual worldwide revenue, or 20 million euro, whichever is larger. And then some lesser violations are a 2% of annual worldwide revenue or 10 million euro threshold. And, nonprofits, I think, are calculated the same way. So I think Joel said CRS, you've done the math on this?
So we are very quickly approaching about $1 billion of worldwide turnover at CRS. Small, teeny tiny portion of that in Greece and Cyprus. But I think the assumption would be that the upper threshold of fines for CRS would be around $40 million if we were grossly negligent, found to be grossly negligent.
Right.
The likelihood of that happening is probably very low, but that's certainly the upper threshold of the fines leviable under the GDPR.
Mm-hmm. And there are, penalty factors in the law. So that's the upper threshold, right? There is discretion to levy smaller fines. But I think we've seen even under existing European law, there's been no hesitation, for example, from UK authorities to fine charities for violations of data protection laws. Okay, so let's talk about consent. So I had mentioned that there's a limited number of bases under which you can lawfully process data. The most common one and the one that's going to apply most broadly is consent. So a question we get all the time as well, we have consent. These are our members, they've come to us, or they voluntarily come to our conference, or, they signed up at our booth at a trade show. Like, these are folks from whom we have consent. Or, we offer credentialing exam, right? We have consent, right, to send information back to these people. Is that true? So I think one thing to understand is how consent is defined under the GDPR, and they've made it a much harder standard. Consent has to be freely given, specific, informed, and unambiguous, and an expression of the wishes of the individual. So what does that mean? Some kind of clear affirmative action, like checking a box that's unchecked, not pre-checked, or, some kind of technical setting or something that indicate consent. What does that mean as not consent? Implied consent. So they became my member, so thus I have consent to market back to them or ask them for, donations or something. Any kind of pre-check box inactivity no longer constitutes consent under the GDPR. And it's important to understand that it has to be specific and informed, which means I think it's very common to say, I consent to the privacy policy, check the box. That's not informed or specific enough to meet the consent standard of the GDPR. Instead, each distinct processing activity is required to have its own consent, because remember, folks have a granular right to opt out of some things and not others. So you might start to see a menu of unchecked boxes. I consent to receive email communications. I consent to SMS text messaging. I consent to, promotion of annual XYZ. And you have to go through the exercise of looking at all the ways you communicate or touch with your database and making sure that you have permissioning to do it all. Also, that you track it going forward to give them the ability to opt out of some things and not others.
Just real quick, this is the thing that's causing the most heartburn in my organization, the idea of consent. And it's especially fraught in our programming because the power dynamic between ourselves and our partners and the beneficiaries that we serve is not equal, meaning that we are often providing some sort of a service, be it health, be it goods, be it cash, and there is an expectation on the beneficiary side that if they do not give us the data we've asked for registration, they will not receive services. So even if they do consent, it may not be freely given. So this is something that we're really struggling with internally, of how to deal with informed consent in those places where there is a legal obligation to do it in this particular way without coercing our beneficiaries to give that consent. Make it clear that they can opt out and still receive services. And that's not just us. That's a back and forth with our donors too, because they're asking for these beneficiary registries. But that's something that's causing a lot of consternation and heartburn and lost sleep inside of CRS.
Mm-hmm. And consent, I think, raises issues in a couple other ways. So one is if you purchase lists, how do you know that the individuals on that list have provided appropriate consent such that you are allowed to do whatever kind of outreach to them that you want to do? That's a thorny one to work through. Another is in the HR context is Joel's beneficiary example, it goes also, consent doesn't work in HR. And this is a position that European authorities have been clear on because the employment relationship is determined to be inherently coercive. So you can't rely on consent in an HR context. The third is, what do you do with data that you already have? And the guidance as to how to implement the GDPR says you are supposed to go back and re-permission it if the original consent you have is not up to the level of the GDPR. Now, is everybody doing that? We'll see. But, you know, this is what you are supposed to do during this implementation period. So if you can't rely on consent, you know, what are the other grounds? And there are a couple others that are interesting. One is performance of a contract. This is an alternative if the data processing is necessary for performance of a contract to which the individual is a party. The typical example here is hotel. So you go online and book a hotel. You're entering into a contract, requesting it, you know, and they can rely on contract performance in that example. I think in organizations where you are, providing some kind of contracted for service, that's potentially a grounds under which you can operate, but you have to kind of analyze your functions. And even if you collect their data and you feel good with contract performance on one hand, you can't then extend that for, you know, some kind of marketing or outreach. You would separately have to consent that data. So you can't, once you have the data stream for one purpose, you can't then extend that more broadly and process data for other purposes. The other is something called legitimate interest. When processing is necessary for the purpose of a legitimate interest pursued by the data controller, nobody's exactly sure what this means. They've given a couple examples. So it's things like fraud prevention. This is one you may be able to use in the HR context, like if you're transferring data between, you know, your payroll provider or something like that. Information security is another one, but it's intended to be narrowly construed. And there are a lot of organizations looking at, you know, how broad can we read legitimate interest? And there's some thinking around that, but I think a standard may emerge after the law goes into effect.
Can I pose a hypothetical on legitimate interests?
Sure.
So let's say that, and this isn't us because we don't operate in the U.S., but let's say I was a nonprofit who was dispatching to Puerto Rico.
Okay.
To provide either health or livelihood services, shelter, food, something like that. Would the act of providing those services in a disaster where the health and well-being of the individual was, you know, the core reason for providing them be considered legitimate, given that the power dynamic is inherently coercive?
Yeah, maybe. Right. So part of the legitimate interest is there's a balancing test where you have to weigh what your interest is against the individual's fundamental rights and freedoms. Right. And I think in that case, right, you would have the more favorable of the argument, but you're supposed to do the whole legal exercise and go through that analysis. Okay. Next myth. So I can use contracts to allocate responsibility. I think we touched on this a little bit. Can you sort of, you know, waive liability? How can you use contracts to your advantage? And this is another place where we see a lot of lift right now as organizations are trying to comply with the GDPR. You are required to have what's called a data protection agreement, a DPA. The law has certain required elements that have to be in it. So the extent that you have any vendors that touch EU data, you are right now, this is a period where everyone is going back and renegotiating and re-signing all of those agreements. There are some public examples. If you use Salesforce, for example, they have published their DPA. Amazon Web Services, they've published their DPA. So some of the really big cloud providers and service providers have kind of just put out there because, you know, they have the market power to make you sign their DPA. But when you're working with smaller vendors, the exercise now is to go back and renegotiate these agreements. And we're seeing that a lot of vendors are trying to, you know, land grab and add more than what's required under the GDPR. Contracts can also be used, I think, to designate, you know, for example, who's in charge of obtaining consent. You use an email service provider. Are they the ones that right now probably under canned spam, they're putting the unsubscribe link and the other, you know, required U.S. legal elements. Are they going to get permission from individuals? You know, is your website set up in a way that's going to get permission from individuals that are going to track that consent? So contracts can be used to kind of allocate those legal responsibilities and to define what that consent could look like. And also, you know, we're telling organizations to try to get indemnity for some of these areas that are going to prove really legally challenging.
How many of you use Microsoft's Office 365 services? A majority of you. So one thing that they just recently released is they're calling it their Service Trust Portal that includes all of their documentation on GDPR compliance and a compliance manager that includes a risk assessment or a compliance assessment for both controls that are the requirements of Microsoft and the controls of the requirements of their customers. It's freely available to all their customers. So if you do use Office 365 and you do perhaps process EU data, that is a free resource Microsoft's made available to you to attempt to figure out whether or not you are compliant using that particular service as it relates to GDPR.
Yeah, and I think a lot of providers are putting resources like that out there, making them publicly available. So to the extent that you may have to, you know, kind of design your own materials, there are a lot of resources like that out there to look at. Okay, one of the new requirements are privacy impact assessments. We talked about them briefly, and a myth is, so everyone hears about the PIA, we have to do one, create one for everything we do. That's not exactly true. So a privacy impact assessment is required in 3 instances, and this is anytime you engage in any kind of processing operation that covers special categories of data. So these data, if you collect data about religion, health, what they call sex life or sexual orientation. There are about a half dozen categories of data that required heightened protection. And if you're collecting and processing that data, you are required to have a privacy impact assessment that looks at, you know, it weighs what the impact on the individual's privacy rights are, what your interest is in collecting that data, how you're going to minimize potential harm from collecting that data. And you have to record all that and have that available to government entities that want to audit or investigate you. Also, it's required if you are processing data that goes to, you know, systematic evaluation of personal characteristics in an automated fashion. I think if you're doing something, and where this comes into play is this is intended to go after behavioral profiling or targeting, which is something that almost everyone is engaged in these days. So if you are trying to, you know, come up with behavioral profiles for advertising or marketing purposes, or to go after particular pools of donors, that has to be analyzed and documented before that goes into effect, or any large-scale systematic monitoring. So this is probably would be only relevant in the HR context. But if you decide to install cameras or something in an office, again, you have to have one of these privacy impact assessments put into place. So you don't need them for everything you do, but they're a required piece of documentation under the GDPR.
I think we've found that these PIAs are one of the most effective tactical responses or mitigations you can employ. We've started to do these in places where we felt that there was a fair bit of risk, and just the act of doing a privacy impact assessment and having a conversation about privacy, even without, you know, setting forth the requirements of a particular regulation, usually results in good decisions on how best to protect privacy of the people who are impacted. We've done these a handful of times, and without fail, folks who don't have are steeped in knowledge on privacy have made very sound decisions, purely because they had the conversation and had a little bit of awareness of the impact of the decisions they were making. So this is, I can't say enough about how important this is, and it's something we're attempting to bake into our standard project management methodologies at CRS.
Okay. Another required new piece of the GDPR, data protection officers. So one of the myths that if we're based in the U.S., we don't have to have a data protection officer or a DPO, and that's not true. Again, it's another test that goes to what activities you're engaged in. So again, if you are doing the systematic monitoring of large groups of people, and that goes to your behavioral targeting or other kinds of, you know, kind of data crunching to analyze groups of personal data, or any large-scale processing of these special categories, you're required to have a data protection officer. The GDPR has pages and pages of what the DPO, how they have to be qualified, who they have to report to, they have to be independent, they have to have a direct reporting line to the highest level of management in your organization. They are the ones that are conducting these data impact assessments. They can be based in the United States. They don't have to be based in Europe if you don't have an office there. But, you know, again, if you meet the test for it, you have to put a DPO in place separately, and it's not covered on the slide. If you don't have a DPO and you have you don't have an office in Europe, but you're subject to the GDPR, you're required to have an EU-based, a physically EU-based legal representative, and they're kind of someone who's supposed to, I think of them as like a process server. They're someone who accepts data on your behalf. It's a hard job because they face personal criminal liability under the GDPR. So I think a lot of organizations are challenged in finding somebody to find that role. DPOs are now like proliferating. If you Google DPO as a service, there are dozens and dozens of firms that will sell you DPO services. The legal representative is another hurdle that doesn't get as much attention, and that's a harder job to fill.
So this is being outsourced, or is an outsourceable role?
It is outsourceable, okay. Yes, yes. And there are consulting firms that can do it. There are some law firms that are doing it. I might end up as somebody's DPO by the time this is all over. Does CRS have a DPO, Joel?
No, not yet.
Is it going to be you?
It might be me. I would prefer it not to be. I'd like, this is not an IT thing. It's more compliance driven than it is technology and security driven. I'd prefer it not to be, but it might be, at least temporarily. And it'll be, if it is, it'll be me with a series of local champions in each jurisdiction in which we feel it's necessary. But that's something we're going to be tackling this calendar year, is what our governance structure looks like around data protection, not just the GDPR, but all of the legal jurisdictions that we're subject to.
Right. And the identity of your DPO does have to be revealed in your privacy policy. Right. It has to be publicly identified. Question?
Enforcing all of these regulations, and I mean, what are the repercussions of not complying?
Yeah, so who's enforcing it? It's a good question. There's a whole section of the GDPR that sets up the enforcement mechanism that applies to government. So right now, European countries all have data protection authorities, DPAs, and that's kind of the equivalent to our Federal Trade Commission, right? They're the lead regulator. Under the GDPR, each country is going to set up a supervisory authority, that's their term, and they're going to be the GDPR regulator. There's a complicated section about how you decide who your supervisory authority is, because you get to make the determination. You have a lead. And you can't just pick the one you think is the most friendly or who you want to deal with. It actually depends where, physically in Europe your processing operations are happening, and you look at factors and you decide, okay, this is our lead. And then the system is designed so that the supervisory authorities cooperate with one another. This was called the one-stop shop, kind of in shorthand, as they were developing the regulation. So before, if you were headquartered in, we'll say, Ireland, you were subject to the Irish DPA, a German citizen has a complaint against you, they would have to physically travel to Ireland to file the complaint, right, which obviously limited the number of complaints. Under the new system of supervisory authorities, that German citizen can go to his local German supervisory authority, file a complaint against you, and the German supervisory authority and the Irish, who is your lead, have to cooperate and investigate it together. So it's designed to facilitate complaints by individuals, and as it is often in United States privacy, a lot of this will be complaint driven. The enforcement will be complaint driven. Although supervisory authorities have, for example, physical audit rights. At any time they can come and physically come to your office. They can demand records. That's all built into the system. I think we mentioned the penalties and how high they are, but it has now also built in kind of the equivalent to class action litigation as part of the GDPR. So private litigants have a right of action for any for privacy harms, even non-monetary ones, and they provide for joint and several liability for if you're working with partners. That's kind of the liability structure. So there's pretty extensive liability here. There are also mandatory audit rights even for parties with whom you contract. So if you use processors or vendors, you have the right to go audit them at any time, and it's expected that you do some due diligence. So it's a regime that's designed for everybody to sort of check on and make it easy for individuals to file complaints when warranted.
We've got about 5 more minutes left, so whatever we want to highlight in this last couple of minutes.
We'll stop on security since that's Joel's area of expertise. I think we mentioned that data security for the first time, breach notification as well, is now part of European law. And something we hear is, we're certified to the ISO standard, we're PCI compliant, we're subject to the HIPAA security rule, so we're good here. What are, I think, the standards under the GDPR? So it is a flexible approach, and it looks at, you're supposed to implement safeguards that are appropriate for the processing activities you're engaged in and whatever, risks. So if you have more sensitive data, you're supposed to have better safeguards. There are no standards currently recognized under the EU, and this is something a lot of the ISO vendors are saying this is a way to become GDPR compliant. That's not necessarily true because it's not a recognized standard, at least not yet. Although likely if you're meeting ISO standards, right, your security is in pretty good shape. So it's a little circular, but don't let security vendors tell you, oh, we have something that's approved under the EU, because nothing has been approved yet there. And of course, they mention a number of best practices like testing, encryption, and things that we've already mentioned that work in the United States as well.
So security requirements and compliance with some sort of security standard is a huge undertaking. And I would not presume that many of you have decided to be NIST CSF or COBIT or ISO security compliant, although it's possible some of you have. Certainly selecting one of those and using it as a basis of design for your security programming is a good start. Any of them is fine. We, for example, use a combination of the NIST cybersecurity framework and the Center for Internet Security Critical Security Controls, formerly the SANS Critical Security Controls, as sort of guiding principles for how we do security. They are, in many cases, mitigations to the decisions you make around privacy. They aren't in and of themselves all that's necessary to be GDPR compliant. As I said, IT is only part of the puzzle when it comes to GDPR. So much of it is organizational culture and policy, and the approach to privacy across your organization. And IT is mitigations to help based on the decisions you make, but it is not enough. We also expect the requirements for security to be fairly fluid based on the outcomes of PIAs that are performed. A very heightened level of encryption or locking down of access in one particular program that's capturing health information in Malawi might employ different security requirements than a housing project in Nigeria based on what we believe the threat is. So it's fairly fluid, but it suggests you pick something. They've all been mapped to each other that works for you based on your jurisdiction.
So I want to be respectful of people's schedules. So this is a good place to break. Kelly, Joel, hopefully can hang around for a few minutes after and answer any questions on things that we didn't get to cover. I want to thank both of you. That was absolutely a terrific presentation. So thank you so much. Thank all of you who are on the webinar and on those of you who are here in person for joining us. I hope you'll be able to join us on February 15th for our next presentation on nonprofit mergers, alliances, and joint ventures. Should be a great one. So thank you all again for coming. Very much appreciate it. And Kelly and Joel will be around for questions to help you out. So thank you again. Have a great afternoon.